Member for Buderim.
Thank you, Deputy Speaker. I rise to make a contribution today in strong support of the establishing a Queensland Community Protection and Public Sex Offender Register Bill 2025, known as Daniels Law. And I want to say at the outset that this bill and these proposed laws are some of the most important and some that I am most proud to support. Queenslanders rightly expect that the rights of victims and the rights of children are placed above the rights of offenders and predators. And that's why Queenslanders, and especially Queensland parents, should know that this government is one that will fight tooth and nail to protect young children, young people in our community from harm at the hands of monsters. And this is just the next step in our plan to do so. Since taking the reins 1 year ago, our government has put in place swift and meaningful actions that are starting to turn the tide on the crime crisis. And our adult time laws got tough on youth offenders, followed by Jack's Law in honour of another brave young man from the Gold Coast. And now Daniels Law is another step forward in our fight to restore safety in our communities. These proposed laws will provide a responsive and a protective tool in the form of a public child sex offender register so that parents and the broader community can have awareness of the presence of convicted sex offender and to take necessary steps to protect their children. The proposed approach to the register, as we've heard, is modelled on the framework established in Western Australia, who were the first Australian jurisdiction who established the three-tiered scheme such as is proposed in this bill. Under Tier 1, facial photographs and certain details of reportable offenders will be publishable by the Police Commissioner if they have failed to comply with their reporting obligations and police become unaware of the whereabouts of the offender. This information will be available to the broader public to ensure awareness and so that parents can take any necessary additional precautions to ensure the safety of their children. Tier 2 of the register allows a Queensland resident to request facial images of certain reportable offenders residing within their suburb or locality. This covers offenders with significant reporting obligations or those who have offended repeatedly against children. The Commissioner may also authorise the publication of information relating to a reportable offender under this tier in circumstances where there is a known serious risk of harm to a child. Lastly, Tier 3 allows a parent, a guardian or a similarly relevant person responsible for the child that they may apply for information about a specific person who is or will be in unsupervised contact with their child. For instance, if a child's going for a sleepover at a friend's house from school where they'll be unsupervised with other parents, the parent can request information through the register about whether a person living in that house is a reportable offender. If that specific person is a reportable offender, then that information will be provided to the requester and further details may also be provided as deemed necessary to ensure the safety of the child at the discretion of the Police Commissioner. It's important to note, however, that the register will not publish photographs or personal details or release any information of an offender who is under the age of 18 or was under the age of 18 at the time they committed a child sex offence in the instance, and this is important, in the instance they have not reoffended as an adult. The register will also not publish that information for those in a witness protection program or those where a court has prohibited such a publication. There are appropriate safeguards in place within this bill. And while I strongly support these laws, I want to stress that this is not an opportunity to encourage vigilantism. The need for parents to be fully informed relating to who their child comes into contact with is paramount. However, information that is obtained or accessed must be treated appropriately and confidentially and cannot be shared with others. As we heard from the member for Southern Downs, under a decade of the former Labor government, there was only one party that sought to establish a sex offender register such as this, and it was the LNP opposition. In 2019, we moved a motion to establish a Queensland child sex offender register, and the government at that time, they voted it down, taking the side, in my view, of offenders over the community. In August 2023, I spoke in this place about how important it was that we implement any measures that would stop sex offenders from committing their heinous acts. I spoke about my support at that time for the establishment of a publicly accessible sex offender register. I spoke in that contribution to the Parliament about the fact that my own community had a sex offender who had been convicted of multiple instances of storing and distributing child exploitation material of children as young as 3 years old. That offender was subject to a sex offender reporting order, but he was still able to access a state school because his child was a student at that school in my electorate. Under the proposed legislation, that same offender would now have their details accessible under Tier 3 of the proposed register. If they were a repeat offender, they would also fall into the Tier 2 structure. And being able to access details such as those are a significant step forward. And I'm so pleased, Deputy Speaker, to be part of a government that is pushing to make this law in Queensland. Of course, Deputy Speaker, none of this would have happened without two very special parents, and I want to take a moment to acknowledge both Bruce and Denise. Bruce and Denise Morecambe are Sunshine Coast locals. I've known them before I was in the Parliament. I see them at the shops, I run into Bruce at Bunnings, at school events, and I'm always proud to walk for Daniel every year alongside them. They are an institution to our community on the Sunshine Coast, but for all Queenslanders and indeed all Australians. And I know that my Sunshine Coast LNP colleagues, both state and federal, will continue to work with them in their endeavours to make children safer, as we have always done. Daniel went to school in the Buderim electorate at Siena Catholic College, at what is now the Buderim electorate. Back then it was the Kawana electorate, I think. And I know that news of Daniel's abduction and murder shocked every Australian, but in particular it shocked Sunshine Coast residents to the core. And my own family are from Palmwoods, which is where Daniel was walking home to, where he would have walked home to, and that's where we walk each year for Walk for Daniel. So it's incredibly inspiring to see the way that Bruce and Denise have managed to turn their despair and their anguish into a positive legacy. A legacy of a safer Queensland where young kids learn how to recognise, react and report. A strong legacy, an unforgettable legacy which ensures that the laws seeking to protect every Queensland child from harm now will, after this debate, bear Daniel's name. I want to commend Bruce and Denise's advocacy, their bravery, their unwavering determination to see this change in Queensland in honour of Daniel. Their work in our schools is incredibly important. I have 4 young children. The eldest is 10, the youngest is 4, and I'm very aware of the concerns of parents and the dangers that our young children, every single young children, deals with on a day-to-day basis, and I'll do whatever I have to protect the welfare of my children, as I will any child in Queensland, and I think that's what all parents expect and want. I recognise that these laws are only one component of a more comprehensive solution, and just as parents will come to rely on information set out in this register, they'll also continue to rely on a strong and active police presence. I want to pay tribute to our police, many of whom sit in this Parliament. I won't name them all, but many of whom sit in this Parliament and have worked to either ensure the monitoring of convicted sex offenders and or the prosecution of those who offend against children, and their work is incredibly difficult, both those who have served in this place but all Queensland police officers and AFP officers, I should add as well, who seek to prosecute the grubs that commit these crimes. I want to pay testament to their work, and as I'm sure all Queenslanders would rightly do. We need more education. I frequently have a discussion with my young kids when we drive under the overpass at Palmwoods there, where Daniel was last seen, and the work that Bruce and Denise have done to drive better education and to open a conversation about these issues is incredibly important. I support these laws, Deputy Speaker, and I urge everyone in the Parliament to do so. This is about honouring Daniel's legacy, but it's for all Queenslanders who will be safer as a consequence. On Friday, I'll again join with Bruce and Denise and with our community, with schools, with mums and dads, grandparents, right across the Sunny Coast community to walk for Daniel, to remember Daniel, but to perhaps even more importantly, remind our whole community and all Queenslanders of the importance of keeping Queensland children safe. And I just want to acknowledge the work of the Police Minister, and I commend the bill.